conciliary and appeal in the matter of Mex Group Worldwide Ltd and another, and Cormack and others.
Yes. May it please your lordships, I appear with Mr. Wright and Mr. Petrides on behalf of the appellant,
Yes.
MGWL.
Yes.
My lords, the respondents, when I say the respondents, defendants 4 and 9, Mr. Gollitz and VDHAG appear by Mr. Kinman, Mr. Calfon and Mr. Kinman. My lords, it's appropriate, I think, that I just spend a tiny amount of time on the question of VDHI, which is the other respondent to this appeal and was one of the applicants below to discharge the injunction. VDHI does not appear today, at least I don't think it appears today. I don't see anyone on behalf of VDHI. And my lords, the position can be stated relatively briefly. It was represented by leading a junior counsel before Mr. Tinkler in December on the instructions of Peters and Peters. It was a respondent to the appeal. It put in a respondent's notice, which is in your lordship's core bundle, on the 28th of March. It was due to put in its skeleton argument in accordance with the timetable in early May. It did not do so. My lords, the reason it did not do so is because it went into a form of insolvency process in Luxembourg, where it is incorporated, I think on the 22nd of April 2024. Peters and Peters were asked by your lordship's court staff to explain VDHI's position. Peters and Peters were unable to give any explanation because I assume they lacked instructions for a considerable period of time. Eventually, my lords, Peters and Peters wrote to the court stating that Mr. Rukavina, who is the insolvency practitioner in Luxembourg, appointed, I believe, by the Luxembourg court to wind up the affairs of VDHI, they wrote to the court to explain that Mr. Rukavina would not be attending by counsel or in any other capacity before this court. They applied to come off the record. Yep. And this court acceded to their application, or Peters and Peters' application, on the 5th of July 2024. So the net result is, my lords, that VDHI is not an active respondent to this appeal, although it has put in a respondent's notice, and it made submissions below and put in evidence below, and that is before your lordship in the bundle. So, my lords, that is where things stand in terms of representation and active participation in this appeal. Your lordships know that this is an appeal listed for 3 days from, in respect of an order of Mr. Tinkler, sitting as a deputy of the High Court, dated the 15th of December, and that was an order given or made after a 3-day hearing before him in December of last year. The order, of course, is in the core bundle. Yep. At page 128. My lords, there are 2 applications which your lordships will have seen something of, which have been made in the recent past by my clients under the Laden Marshall jurisdiction. I'm going to come back to those in short order, but it occurs to me that this court may be assisted before I launch into my application or my applications under the Laden Marshall principle. It occurs to me that it may be of assistance to your lordships if I was to just sketch out the relatively complex procedural path that has led to this appeal. Before I do so, my lords, I should also just simply record something or say something about the bundles before your lordships. I'm afraid your lordships have been burdened, and I regret this, with a good deal of documentation. The bundles can be divided up as follows. There is a short core bundle containing skeleton arguments, notices of appeal, judgment, etc. That is a slim volume running to no more than 200 pages. Yeah. My lords are also burdened with a rather longer bundle, which is what is known as the supplemental bundle. That runs to, and I regret to have to say this very word before your lordships, some 3,000 pages. I very much hope your lordships will not be belaboured with much of those 3,000 pages, but necessarily, given that it is part of the case for the respondents, by way of respondent's notice, that the judge below erred in concluding that there was a, quote, good arguable case. and how that fits into the legal. I'll come on to how that fits into the general legal universe in this case, although I'm sure your lordships know only too well. The fact that that question has been put in issue by way of respondent's notice necessarily means that your lordships, I regret to have to say, will have to spend some time, will have to be shown some of the underlying documentation which was shown to Mr. Tinkler at first instance. My lord,
Mr. Grant, you take the court whatever course you wish to take.
Thank you,
but so far as we are concerned, that is a matter for the good arguable case is not part of your appeal.
No.
And it's for the respondents to develop that case in due course, and we'll hear you in response to that.
Well, that's very helpful, my lord, in which case I will, that will very much concertina the submissions I need to make to your lordships by way of my opening address,
And I'm not sure
so to speak.
in this case that anybody's arguing the contrary, but you could assume, I think both of you, that the test is what's known as the Niedersachsen test.
That's certainly been my understanding, my lord.
It's not. There is a pending appeal, half-heard appeal before this court, which actually I'm hearing the rest of on Friday, where that point is in issue. But I don't think I'm giving much away if I say that you should both proceed on the basis of the Niedersachsen as to.
Is that an appeal in Magomedov, or because I know there's been some recent learning in the area, and Mr. Justice Butcher.
There's some recent learning in the area, yes, including a case that's on appeal.
Yes.
But I'm only saying that so that nobody wastes time arguing something that really doesn't need to be.
I should say one of the few things that is not in issue at the bar, which doesn't divide my learned friends and myself, is the proper test, in the sense of we have promoted the proposition that Mr. Justice Butcher in Magomedov and Mr. Justice Bright in, I think, Unicredit.
Unitil, yes.
I'm so sorry. We're both, with the greatest respect, correct in their appreciation. I know there are cases on the other side. There's Mr. Justice Edwin Johnson's judgment in Harrington and Charles, etc. Your lordship is all over this point, I'm sure, much more so than I am. But certainly at the bar, I think it's accepted that the test is laid down, the time-honoured test of Mr. Justice Mustel, as he then was in the Niedersachsen, as your lordship pointed out many years ago. So I'll say no more about that. My lords, in terms of bundles, therefore, you have this rather bloated supplemental bundle. That was a bundle which caused Master Meacher a certain amount of disquiet, and I quite understand the learned master's concern about that. She ordered a smaller supplemental bundle. That has been produced, a sort of halfway house between the core bundle and the supplemental bundle. And finally, your lordships have the Laden Marshall bundle, which is, I'm afraid, quite a long document in itself. But I'll come back to that.
So
I just wanted to
the core supplementary bundle, which speaking for myself, I didn't get to Friday. That's a sort of greatest hits, is it?
Well, it could be described. I have to confess, my lord, if I can be candid with your lordship, that I didn't find it the most helpful bundle, because it contains some little excerpts. But I find when you have an affidavit below, it's preferable both for myself and, more importantly, for the court to have the full affidavit and some greatest hits from within, or bon mot from within the witness statement doesn't necessarily assist. But there we are. That's what we have, and I won't be troubling the court myself, unless pressed to do so, with the smaller supplemental bundle.
No, okay.
Your lordships have the longer bundle, which contains a lot of material which I very much doubt your lordships will ever have to trouble themselves with. But we'll see how my learned friend has to makes his submissions on that. My lords, so just explaining, if I may, very briefly, how we have got to where we have got to. It's a relatively complex procedural path. The narrative starts, my lord, in Scotland. Of course, some historians might say the narrative starts rather earlier, but I will, for my own purposes, will start it in Scotland. And it starts before the Court of Session on the 17th of October 2023, when the Dean of Faculty and Mr. Brown attended before Lord Sanderson in the Court of Session and sought two orders from his lordship in Edinburgh. And your lordships have in the supplemental bundle two originating processes in Scotland. One is called a summons, and that is at page 1737 of the supplemental bundle. I don't take your lordships to it at the moment, unless your lordships want me to do so. That is as I apprehend it, the Scottish analogue of a Part 7 claim. I'm sure the learned Scots would deprecate the analogue because they have a very, quite rightly so, high opinion of their own processes. The summons is at 1737, and there is something called a condescendence at page 1741, which, as again, treading softly, I perceive as the analogue to a particular claim in England. And if one reads it, and I've read it many times, maybe your lordships have touched upon it at least briefly, it reads very much like an English particulars of claim, and sets out a claim brought by my client against the 12 defenders in Scotland in two causes of action, which seem quite similar to the way we English lawyers talk about causes of action. It talks about unlawful means conspiracy. It talks about inducement of a breach of contract. My lords, that is the first originating process that was issued in late or mid-October last year. The other piece of originating process that had been issued or was on the verge of being issued was a petition. That is a bespoke piece of originating process, so it would appear under a particular act of Parliament particular to Scotland, which is a petition which allows one to seek what is, and I again use the phrase very loosely, the Scottish analogue to a search order. And it is quite plain, my lords, from the documentation that is within the bundle, that the search order that was sought is purely ancillary to the causes of action issued and brought by way of the main originating process, viz. The summons. So those were the two pieces of originating process that were before the court at an ex parte hearing on the 17th of October. And what the Dean of Faculty was seeking ex parte on the 17th of October was two pieces of ex parte relief. The first was sought within the summons, and there's a particular paragraph or set of paragraphs relating to it. And it is known, as I understand it, as a warrant of diligence. And that is again speaking very loosely indeed, a Scottish analogue to a freezing order. There are differences, and significant differences, between a warrant of diligence and a freezing order. And those, I think, can be said in very summary terms as follows. Scotland does not, as a matter of practice, issue process or make orders, rather, which have extraterritorial effect. And there's an opinion of the Scottish junior advocate in your lordship's bundle explaining that, which I may have to come back to at some stage. The other aspect of the jurisdiction is it doesn't attach to defenders in the way that freezing orders do. It attaches to items of property or bank accounts within the jurisdiction of the Scottish courts. So the first piece of ex parte relief being sought on the 17th of October was this quasi-freezing order, noting the differences. The other ex parte relief being sought was what I would describe as a search order, using the phrase loosely, and that was directed at, or sought to be directed at, 3 addresses in Scotland, 2 addresses in Edinburgh, 2 domestic addresses in Edinburgh and 1 business address. And those addresses were the addresses of Mr. Ford and Mr. Cormack, who are the first and second defenders in Scotland and ditto in England. And the third was a business address of 3 companies who are likewise defenders in Scotland and defendants in England. The 3 companies your lordship see it. Ds 5 through to 7, 2 of them Scottish companies, I think one of them an English company, but with a Scottish address. And Lord Sanderson received submissions on that day and was persuaded to grant the 2 pieces of relief, no doubt making tweaks in the way that courts often do to ex parte orders. My lords, those 2 orders therefore were made, and the warrant of diligence is, I think what essentially happens is that one serves banks in Scotland, and then if there happens to be a bank account in the name of the defenders, then it's frozen. If there doesn't, then it means it has no impact. And otherwise, the petition search order was executed, and there's an interesting aspect to Scottish procedure in the sense that the search order is not executed by the claimant or the pursuer via its solicitors, but is executed by commissioners appointed by the court, and in this case 3 very eminent KCs in Scotland were appointed, each for the 3 addresses. They attended with their entourage. I'm not sure who precisely was within that entourage, it may not matter. They attended those 3 addresses the day later or so, or perhaps the day after that, doesn't matter, and they executed the order and took away computers and imaged them, and therefore came into possession of very large quantities of virtual and possibly physical documentation as a result of that order. And what then happened is a long process, which I will come back to in due course, of considering the documents, creating a report, all done by the commissioners. My clients see nothing of this because it's all done by the commissioners on behalf of the court, and various developments then occur in February, which I will come back to. But let me stay in October for the time being. That's what's happened in Scotland.
You mentioned that Scotland does not, as a matter of practice, make orders with extraterritorial effect. For my part, it might be helpful in due course to understand a bit more about that, whether for example, it has the same power to do so as we do in England, but chooses for some reason not to do so, and if so, why not? But not necessarily for now, but it seems to me that may be relevant when we get to the expedient.
I quite understand that, but I don't want to shy away from your lordship's question, because in fact, Mr. Jonathan Brown, who was the Dean of Faculties Junior before Lord Sanderson at the ex parte application, and remains very much part of the legal team up in Scotland, he produced an opinion which was presented to Mr. Justice Lavender at the hearing I'm going to come on to in a second, where he explained the nature of the jurisdiction and its limits, and effectively how the Scottish courts have chosen to exercise it. And just for your lordship's note, I won't go to it now, but I will of course come back to it. For your lordship's note, it's page 2127 of the supplemental bundle. That is, if your lordships have it in hard copy, may well be in the 3rd, well actually I don't know how many volumes your lordships have in it. It may be the 3rd volume.
2127.
Or rather, I think it actually may be yes, it's well, the affidavit is. The affidavit is in fact, there are 2 documents produced by Mr. Brown. There is an affidavit at 2127.
Yep.
But there was also an opinion which he produced, which, let me just give you precisely that reference. It's page 1727, which again, it may be in volume 2. But just if we just turn to that straight away, it's an opinion. It's an opinion produced and dated, I think, the 18th of October. So literally the day after the hearing in the before Lord Sanderson, the day before the hearing.
1727.
1727. I do apologise.
Thank you very much.
And what?
Tab 88.
That's it. I'm so sorry. I should have given you the tab number. The essentially what it is, it's a if I may say so, a learned and interesting analysis, not particular to the facts of this case, as to the nature of the jurisdiction exercised by.
It's to do the worldwide freezes. Yeah. Okay.
He explains the nature of the various types of order that can be granted by a Scottish court. He talks about inhibition, para 5. He talks about arrestment, para 7. He then turns to diligence on the dependents, which is the phrase, I use the word warrant of diligence, and there are various ways of putting it, a paragraph 11. And it is really paragraphs 11 through to the end, which I think may answer my Lord Justice Males's question. And we get to the conclusion at 21. I wouldn't want in any way to not to encourage your lordships to read the totality of those 5 pages, because they may be of assistance to your lordships. But I think the conclusion may be set out at paragraph 21. Not that there's any policy specific to freezing orders, but rather there's a general reluctance to grant orders having extraterritorial effect, and an encouragement to litigants to seek such orders in other jurisdictions. But my lords, I wouldn't want to hasten over that document. It's a useful document, but I just for my lord's note, if that's convenient, paragraphs 11 to 21 are of assistance in answering my lord's question. My lord, now let me cross the border back into England. 17th of October has happened. Lord Sanderson has been persuaded to make those two orders, and then the claimant comes before this court, or rather the King's Bench Division, the English court, before Mr. Justice Lavender, by way of a Part 8 claim issued on or about the 19th of October, and seeking worldwide freezing orders against all the 12 defendants, bar, I think, Mex Securities, the 11th defendant, which has got into insolvency, seeking permission to serve out of the jurisdiction, and seeking permission, because all the defendants are out of the jurisdiction, and seeking permission to serve by alternative means. And Mr. Fennell's KC appears before Mr. Justice Lavender on the 20th of October, I think it was, and your lordships have the transcript of the submissions that Mr. Fennell's made on that occasion, and it went on for more than half a day, I think I'm right in saying, the submissions. There are affidavits, of course, before the court. There is a large bundle, there's a skeleton argument, and Mr. Justice Lavender is persuaded to make the order, which we might, we can see the order at tab 96, page 1906 of your lordship's bundle, which may be volume, I think is volume 3 of your lordship's bundle. We might just briefly look at the order that was Mr. Justice Lavender was persuaded to make. It is, as your lordships will see, it's tab 96, 20th of October. It's against 11 of the defendants because Mex Securities was not included within the order, otherwise the same. And the freezing order is, we see at paragraph 1 in a conventional form. There is a return date ordered at paragraph 4 in conventional form. The order is very much in conventional form. The amount at paragraph 10 of 85 million euros at paragraph 10, and then the orders for service out are start at paragraph 26. And my lords, for your lordships, note the transcript of the hearing is at page 1888 of the supplemental bundle, and there is a skeleton argument, as one would have expected, which is at page 1779 of the supplemental bundle. My lords, the order was served in accordance with the terms of the provisions for service out and alternative service on all the defendants, and it's worth spending a little time just to put your lordships up to date as to where things stand with the totality of the litigation, because of course your lordships only see 2 of the respondents or defendants represented today. My lords, what happened was that there was a first return date, as ordered by Mr. Justice Lavender, which came before Mr. Justice J on the 2nd of November. Your lordships even have the transcript of the argument before Mr. Justice J, but I'm hoping your lordships are not going to be shown that, because it's not of any, without any disrespect to anyone, of any great moment. But there was a hearing. At that hearing, my lords, VDHI was represented, as I've mentioned before. My learned friends' clients were represented, and also, I think, represented were what we've described as the so-called Ford defendants. And those are the 5 defendants, Ds 1, 2, 5, 6, and 7. That is Mr. Ford, Mr. Cormack, and the 3 companies, 5, 6, and 7. They were also represented by separate counsel, and they were instructed a firm of solicitors called Cook, Young and Keaton, the CYK defendants as they were known. And Mr. Justice J, for reasons which I don't need to trouble your lordships with, set down a bifurcated timetable for challenge insofar as the defendants wish to challenge. A timetable applicable to VDHI and VDHAG and Mr. Gollitz, its CEO, and a timetable for the CYK defendants, which was rather more prolonged for reasons we don't need to trouble ourselves with now. Otherwise, Mr. Smith was not representative, that's D3, nor was CSM D8, nor was Mr. Volotovsky D12. That was the position as it stood on the 2nd of November. And my lords, let me just digress for a second as to the position of Mr. Smith, CSM, and Mr. Volotovsky. My lords, just to remind your lordships, Mr. Smith, who is an important figure in the background history to this case, and indeed to the foreground procedural narrative of this case, Mr. Smith was the individual who was, we say, de facto and then de jure manager of Mex Securities, who was the gentleman who flew to Dubai on the 8th of December and engaged in the hotly contested negotiations in Dubai with Mr. Nasser Tahir and various other multi-bank personnel to lead to the settlement which was engrossed in a BVI Tomlin order, which is the subject of hot litigation, or was at least the subject until recently of hot litigation, which I'm going to come back to that. So Mr. Smith is an important figure. He's also the founder, or a founder, of CSM, D8, which is another important figure, or company, or player in this narrative, and which I'll also come back to. Volotovsky was also a de jure or de facto, I use the words very loosely because I don't want to get into contentious questions, manager, director of Mex Securities. So those three defendants did not appear, I don't think, before Mr. Justice J, and indeed they have participated in no shape or form before this court until very recently, because they were obliged by the freezing order to put in an affidavit of means, and none of them did so. And there are committal proceedings ongoing against them, which are in fact due to be heard next week in the King's Bench Division. And Mr. Smith has latterly appeared as a result of those committal proceedings, but he's not put in an affidavit of means and has not participated in any meaningful way in the underlying Part 8 claim in England, either claim which is before your lordships now on appeal. So that's, in brief, the position of Smith, Volotovsky and CSM. My lord, as regards what I describe as the CYK defendants, I've mentioned that Mr. Justice J laid down directions. The directions applicable to CYK permitted them, if they wished to challenge the freezing orders, to do so by the 2nd of February of this year. And they duly exercised that entitlement and issued an application to challenge on the 2nd of February with affidavits and what have you, served on my clients, and we've beavered away to put in responsive evidence to the CYK defendants' application. However, we were all gearing up for yet a further prolonged hearing before a judge of the King's Bench Division, where they were challenging the order as against themselves. Of course, the Tinkler order doesn't have any effect on them. But peace has recently broken out, my lords, as between my clients and the CYK defendants, in the sense that there has been a consent order whereby they are now willing to consent to the freezing order made against them to continue to the trial of the Scottish proceedings, because of course they're merely ancillary to the Scottish proceedings. And indeed they agreed to pay my clients costs of responding to their application. So as regards the CYK defendants, all is quiet on the Western Front, and the matter is being litigated against them in Scotland. They have been, of course, rather more active in Scotland, as I will immediately come on to explain to your lordships, they being the defendants, the Ford defendants, as I described them as. My lords, as regards the VDH defendants, just to pick up the narrative as regards them, they, in accordance with the J order, issued their application to discharge, both of their applications to discharge, because they're separately represented, VDHI represented by Peters and Peters, VDHAG and Gollitz represented by Howard Kennedy, instructing my learned friends. They issued their application on the 16th of November, put in a bunch of a welter of evidence in support of that. My clients then responded with a welter of evidence in response on the 1st of December. Massive amounts of evidence was then put in. It's all, sadly, in your lordship's supplemental bundle. The matter comes before Mr. Tinkler, sitting as a deputy judge of the King's Bench Division, starting on the 12th of December. And as your lordships know, there was a 3-day hearing. Mr. Paul McGrath was the leading counsel, the leading counsel on that occasion, and he represented my clients, and there was a 3-day hearing, at which only the VDHI defendant and the VDHAG and Gollitz defendants were represented. And my lords, that led to the judgment of Mr. Tinkler, which is in your lordship's core bundle, page 131, and the order appealed against, which is at page 128. And we might just very briefly look at the core, in the core bundle, if it's convenient, look at the order which is appealed against. It's not it is in conventional, relatively conventional form. My lord, it is at page 128 of the bundle, which is tab 9 of the bundle. A very large number of recitals to explain all the various aspects of the procedural chronology that occurred in the period since the issue of the proceedings. And your lordships will see that paragraph 1, the order of Mr. Justice Lavender was discharged against the VDH defendants, as I'll describe them. They had separate representation. The Part A claim was set aside against them. The continuation application, as the dominoes fall down, were dismissed, and then there were substantial cost orders made against my client at paragraphs 4 through to 7, and so on and so on. And the judgment, my lords, is at the very next tab 10, I think it is, page 131. I won't look at it now with your lordships, though of course I will take your lordships through to it in short order. My lords, keeping with the English proceedings for the time being, my clients then worked hard over the Christmas period to work on their appeal. A skeleton argument was put in, a notice of appeal was put in on the 4th of January. As regards the freezing order that had been, or the freezing orders that had been discharged by Mr. Tinkler, he was persuaded to continue them pending a consideration by the Court of Appeal. So he continued them to the 5th of January, which was the 21st day. And on the 4th of January, my clients put in their notice of appeal and skeleton argument. They also sought a stay of the discharge of the order. That came before Lord Justice Nugee on paper on the 5th of January. Lord Justice Nugee, of course, couldn't consider the application for permission to appeal itself. That was a substantial undertaking in and of itself. But he continued the freezing order until such time as a Lord Justice or a Lady Justice had considered the application for permission to appeal brought by or made by my clients. So the order continued. That application for permission then came before Lady Justice Andrews, on paper, of course, on the 14th of March, and she granted permission. The document is at page 179 of the core bundle at tab 13. She also was persuaded to continue the freezing order as against the VDH defendants until this appeal had been determined. So that's where things stand. That's where things stand in respect of this appeal, subject to the Laden Marshall question, which I'll come back to. My lords, what are the Scottish proceedings? Your lordships are no doubt asking with great curiosity. Well, the answer is as follows. The Scottish proceedings, we last left them on the 17th of October with Lord Sanderson's ex parte orders and with the commissioners having executed the search order. Now, the usual scenario is that if there is no challenge to the search order, then the commissioners, subject to the court order, will hand over the documents to the pursuer and the applicant who had sought the order in the first place. But in this case, which does happen, on the 1st of February of this year, having allowed 3 months to pass, and more than 3 months to pass, the Ford defendants against whom the search order had been executed, those 5 entities, two gentlemen, 3 companies, issued an application using the English terminology to set aside the search order, and indeed to set aside the quasi-freezing order. And they made an application on the 1st of February, and that application came back before Lord Sanderson over 3 days in April. And there was an intense 3-day hearing before the learned judge in Edinburgh. Massive amounts of evidence, as I understand it, put in on both sides, a lot of argument. And the judge then, having heard the argument, effectively the argument on behalf of the Ford defendants fell into 2 broad categories, so I understand it. One was there had been breaches of the duty of full and frank disclosure before Lord Sanderson on the 17th. Much as the same point was made, of course, in England, and I'm going to have to deal with that. So the first thing that was said was a lot of breaches of duty of full and frank disclosure, justifying the setting aside of the 2 orders. The second point that was said was the claims themselves did not articulate, and I'm using the phrase now very broadly because there's an issue about this, a prima facie case or a good arguable case. And essentially they said there wasn't a proper case put forward. Therefore the freezing order should never have issued. Now, without wishing to preempt a live debate on this, because it's important I do it within the context of the actual formal issue that's been taken by my learned friends, Lord Sanderson rejected that challenge, upheld both orders, and then after a couple of weeks having taken time, or 3 weeks having taken time to consider his judgment, he then handed down formal written judgments on the 17th of May. And those 2 judgments are before your lordships, and I'm going to have to look at them with you in short order. Now, for your lordship's benefit, in terms of working out the procedure relating to execution of the search order, I'm using that phrase, I know it's an English phrase, I'm using it advisedly therefore, without suggesting it's in every single shape or form the same as an English search order. Mr. Hastings, in his first witness statement in the Laden Marshall application, at paragraph 37, has very usefully, if I may suggest, set out the procedure, I don't think there's any contestation about this, as to how they work in Scotland and how, in this case, they were executed. My lords, the two judgments were therefore handed down. And that then left the question of, well, what do the commissioners do with these documents, which they have recovered from the 3 addresses in Scotland? And that's not just a matter of just, here you are, whack them over to the pursuer. That requires court intervention and court order, because the courts in Scotland are very concerned to ensure that search orders are in every way regulated by the Scottish courts. So the matter then came back before Lord Sanderson in early June, and then there was a question mark about privilege and confidentiality. Having lost on the so-called root and branch application, the Ford defendants then said, well, hang on, some of those documents are privileged, and you can't, of course, the pursuer can't see those, and in fact, perhaps more strangely, said some of them are confidential. Perhaps there's some principle of confidentiality in Scottish law, I know not, which allowed them to be withheld from the pursuer. But as regards the bulk of the documents, they made no complaint. They didn't say they're privileged or confidential. So the court ordered, Lord Sanderson, that is, ordered that a large amount of documents recovered by the commissioners be handed over to my clients. And they were duly handed over on, I think, the 6th of June. And those are known in the skeleton arguments and in Mr. Hastings' witness statement as, quotes, the uncontroversial documents. They're very controversial in all sorts of ways, but they are uncontroversial vis-a-vis the challenge of privilege and confidentiality. They were handed over on the 6th of June, so 6 or 7 weeks ago, 12,000 of them or so. And they were looked at by my client's Scottish lawyers. And of course, we knew, and they knew, that this appeal was looming. And therefore, working at lightning speed, the Scottish lawyers, Mr. Brown and his solicitors, looked through those 12,000 or so documents to work out whether there were any that might be of any relevance to the matters raised on this appeal. And with heroic, if I may say so, heroic fortitude and speed, they identified 93 documents which they thought might be relevant to this appeal in London. But of course, they couldn't just hand them over to the English lawyers, because there are, as you might imagine, as there are in England, there are constraints on the use of documents obtained by the kind of methods of a freezing, of a search order. So they had to go back to court, back to Lord Sanderson, and they did so on the 19th. So they did so within, well, they actually applied on the 11th, so within 5 days. And those were long, dark nights of the soul, I suspect, for the Scottish lawyers, whizzing through 12,000 documents. But they knew they had to work quickly, and they did so, and they located 93 documents which they thought might be of assistance in this court. And they had to go back to Lord Sanderson. They applied on the 11th of June. The matter came before Lord Sanderson on the 19th of June, and he granted permission to MGWL to hand over those 93 documents to its English lawyers, i.e. me, Mr. Wright, and the solicitors who sit behind me, Mr. Petrides, to make a decision on whether to apply under the Laden Marshall jurisdiction to bring those in and seek to reduce them before your lordships. Now, we on this side of the court, again, working at extraordinary pace, if I may say so, extraordinary pace, made our first Laden Marshall application within a week or so of receiving the documents. And we didn't just chuck in all 93. We thought we don't want to just burden the court and the respondents with all the documents. We whittled them down to 68 or so documents and made our application and served it on the Friday, the 28th of June. So that's the first Laden Marshall application. And Mr. Hastings put in then in fact, if I can invite your court lordships now to turn to it. I'm now going to the meat of this application. If your lord, I don't know if your lordships have I know your lordship got a lot of bundles, a specific Laden Marshall application bundle.
Yeah.
It's the witness statement of Mr. Hastings is at tab 3, page 13.
Mm-hmm.
And it's a 15-page witness statement or so, 12-page witness statement or so, which deals with a number of different documents. The judgments of Lord Sanderson, the 68 documents from the recoveries, and a couple of other bits of paper which I'll come back to.
Mm.
And he explains, and this was done at absolute lightning speed, because we didn't want to be holding documents back. He explains at paragraph 43, page 24, in the very limited time we had to consider them, what they went to. These documents went to paragraph 43. Now, of course, by this stage, the 28th of June, we're in the process of preparing for this appeal, which is no mean task, I should say, having been at the coalface for some weeks on it. It's obviously a very substantial appeal with a unusually large number of facts. So, my learned friend solicitors, having received this, the next week say, well, tell us what each document goes to. And we wrote back saying we will. And we produced a skeleton argument of 31 pages, which I regret the length, of course, to your lordships, and a separate appendix of 17 pages. So we produced 48 pages of submissions concerning these documents. And the task, as I hope your lordships will recall from your own time at the bar, the task of producing a 31-page skeleton argument, a 17-page schedule, where we're not just simply saying document 3 goes to good arguable case, document 4 goes to risk of dissipation, document 12 goes to full and frank disclosure, which would have been a totally facile exercise. But in fact, we're developing submissions, which of course take time to develop and to place these documents in the huge universe of documents that exist in this case already. So what we're doing in that skeleton, which your lordships may have had occasion to read, and I'm sorry you've had to, I'm sorry to have disrupted your preparation for this appeal in imposing this skeleton argument on you. But it was a skeleton, I know that because I spent quite a lot of time on it myself, that required an awful lot of time to craft, to actually explain to your lordships in a sensible and forensic way why document 34, whatever it might be, why that's relevant to the issues on this appeal against the background of hundreds of pages of affidavit evidence, thousands of pages of underlying documentation. But we did it, and we served that on the 15th of July with the 17-page schedule at 1 p.m. So a week ago, exactly a week ago. And I mention this because my learned friends accuse those on this side of the court of idling and of why don't you get it done quick enough? And that I take that as a criticism myself, and of course they're entitled to criticise me, they're my learned friends if they wish to do so. But if I am criticised, I wish to explain myself. This appeal involves, as your lordships know only too well, an immense number of difficult points of law, an immense number of points of fact, an incredibly complicated procedural chronology. And I don't mind telling your lordships that in many, many years at the bar, the last 3 weeks have been probably the hardest 3 weeks I've ever had to encounter in terms of preparing this appeal, and also deeply involved, so I don't let my juniors just do things for me, deeply involved in preparing a very long skeleton argument to try and explain to this court why these documents coming in as they do are important to this court. And I say this immediately. And I say it because my learned friends put in issue good arguable case. These documents are of the highest materiality to the outcome of these proceedings in Scotland. They have already been pleaded by way of amendment in the Scottish pleadings, and let me make good that point. My lords, the way things work in Scotland is that you are given, apparently by the judge, or can be given, a general permission to amend or adjust within a window of time. And Lord Sanderson gave a period of adjustment, I think in June, which ended on the 15th of July. And my Scottish brethren, so to speak, exercised that right of adjustment, having considered the documents that came out from the search order, and put in a new pleading on the 15th of July within the window of time allowed them by Lord Sanderson. It's tab 11 of your lordship's Laden Marshall bundle, and in the usual way it's in red. And what they have done, Mr. Brown and whoever else assisted Mr. Brown, is bring in a large number of the documents that have been produced in Scotland and plead them. And we can see it all in red. I haven't got time to take your lordships through it.
I only have 10 tabs in mine.
Right, that's a huge problem.
Yeah, I've got 10 tabs in mine.
No, I think, my lord, this is because this came in on Friday, because it has Mr.
I'm doing
Gollins's.
my best to keep a track of all of these various documents, but I'm afraid I don't have this.
No, I quite understand your lordships. What happened
And
is,
can I just for clarification, in relation to the Laden Marshall bundle, the skeleton isn't one of the documents referred to. I've seen red marked up the skeleton, but I have that separately because my clerk prepared me a bundle for these documents
yes.
in advance of getting the Laden Marshall bundle. So I have the skeleton, but I have it separately.
Do you have my learned friend's skeleton
but
as well?
I also have the schedule to the skeleton, which is not, because my clerk appears to have just photocopied it. The schedule to the skeleton is cut off, because it's obviously in, I don't know if it's an A5 or what it is, or
Ah,
landscape or something.
well, it may be, well, I will,
For
It is a-
my,
it is
for
an
my
A-
part, I have read your skeleton electronically, but I don't have a hard copy with me, and I haven't seen one from Mr. Coulson.
there was one on the 5th, there was one served on Friday by my learned friends.
That's fine, but I haven't seen it.
Well, I'm sure, I think Mr. Kimmer's going to hand it up to your lordships. So, but let me, I'm so sorry about this, but things have been moving at pace, and let me just explain what further happened, which made things even more complicated. So, just to, I'm so sorry to belabor your lord.
We're prepared to listen to whatever argument the parties want to raise about these latest documents. But on the face of it, if they're documents that were obtained through the search order in Scotland that weren't previously available to your client, it's a bit difficult to see why Laden Marshall principles wouldn't apply.
Well, I respectfully agree, but there's a substantial submission made against me. Let me take my
Can I
course
just
on.
ask, did Lord Sanderson give a judgment when he gave permission?
He didn't,
did he
because
just-
it went by way of, it's a very pertinent question, if I may say so, respect. Basically, what happened, my lord, is this. We get the document. When I say we, the Scottish lawyers get the documents. The 12,000 of them, whatever it is, as I say, at pace they whiz through them. They try and locate documents that might be relevant to this appeal. They're conscious that if they go back to Lord Sanders and say, can we have permission for all 12,000 documents, and then whack off 12,000 down to London, that's not going to go down very well with Lord Sanderson. They make a narrow application in respect of 93 of the 12,000. They make that on the 11th of June. That goes before Lord Sanders on the 19th. The Ford defendants do not oppose the order, which is why there's no judgment. But the order is absolutely necessary, because otherwise we're probably in contempt of court, which we don't want to be.
No, I understand that. I just wondered whether he'd given a judgment,
No, he didn't.
which might, for example, indicate his attitude to these proceedings in England. Obviously, the fact that he gave you permission tells us something.
Yes.
I wondered whether he,
Fair point.
as it were, said anything.
My lord, he didn't. I don't think he said it. I don't think anything. No, he didn't say anything of note in that, other than willingness to grant the order. But my lords, I need to explain the fact that there's a flurry of further of procedural activity. I'm afraid I need to unfold to your lordships a further set of events, which is that I told your lordships about the privilege documents which were held back. What Lord Sanderson said was that I'm going to actually make decisions on the privilege question. And he therefore goes through the documents in respect to which privilege is asserted and makes individual decisions on whether the privilege is to be upheld or not. And what he did on the 4th of July, so we're now 19 days ago or so, 18 days ago or so, he, having looked at a first tranche of these privilege documents, said, well, these 38 are definitely not privileged, they can go to the pursuer. So he released a further batch of documents on the 4th of July. Again, I know I've said this point before, but my client's Scottish lawyers, working at, again, lightning speed, looks through those documents and locates a number which they think might be of relevance to this court. They make their application literally the next day, having received on the 4th. They've never seen these documents in their life before. They make the application on the 5th, back to the Lord Sanderson. It comes back before him on the 11th, so we're talking about 11 days ago. Lord Sanderson again gives permission without dissent from the Ford defendants. Those documents reach my solicitors in London on the 11th, 11 days ago. We look at them at lightning speed, and we make a second Laden Marshall application in respect of documents we'd not seen except before the Thursday the 11th, on the Monday. And that required, and I don't want to start patting myself on the back too much, but that required enormous amount of work to get that up and running and to put in submissions which we did within the same skeleton. So we put in a compendious skeleton on the 15th. We just sent it out. We didn't want to exchange or anything like that. We sent it out because we didn't want to steal a march on anyone on the 15th, which is a week ago. My lord, so there are two applications, two witness statements. There's one skeleton argument served by us on Monday, midday or 1 o'clock at Monday last week. What then happens, and this is why your lordships are having further documents put in the bundle, is that my learned friends put in a witness, my learned friends solicitors put in a witness statement from Mr. Gollitz, giving his explanation in respect of such as he can of all the documents that have been the subject of the Laden Marshall application. There's a 5-page witness statement from Mr. Gollitz served on Friday. I make no complaint about the timing at all, of course. And a 31-page skeleton argument or so served by my learned friends at the same time on Friday. And the new tabs in your lordship's Laden Marshall bundle, which obviously hadn't got to you, are tab 11, the new amended condescendence or adjusted condescendence, bringing in a number of the documents and pleading them out as relevant to the underlying conspiracy claim. Mr. Gollitz's witness statement at tab 12 and an exhibit to Mr. Gollitz's witness statement at tab 13. So it's a moving target. Things are moving at pace. And the sole determinant of the timing of these applications has been the fact that we sought a search order many months ago, we obtained it many months ago. The reason the documents have been clogged up in the system, so to speak, is because the four defendants fought a rearguard action from the 1st of February through to April to keep those documents out of my client's hands. And once one looks at those documents, one can well understand why they fought that rearguard action, because they are highly material to the underlying claims, not only against the four defendants, but against all the defendants, including my learned friends' clients. That's why they've now been pleaded out in extenso by Mr. Brown up in Scotland in the adjusted pleading. And they contain documents which are, we would say, my learned friends disagree with this, of the highest materiality to the question of A, good arguable case, which is a question my learned friends, as your lordship knows, contest by way of respondent's notice, and B, risk of dissipation, because we say they show, I regret to say this, we say they show Mr. Gollitz, the CEO and director of VDHAG, telling lies to this court below. Now, let me say this. So we've got this application.
Just before you go any further, speaking for myself, I do not have a skeleton argument in opposition to the Laden Marshall application from the respondents. I've got your skeleton argument, which, as I say, the schedule is, somebody's going to have to provide me with a schedule that's readable, but I haven't got their skeleton argument at all. Now, whether it's because documents were arrived at some time on Friday, that went to my clerk and haven't been passed to me, that's a possibility, because it wouldn't be the first time, but I don't have them.
I'm very sorry, my lord. It was served on Friday morning. I had thought that it had made its way to your lordships. It obviously hasn't. We are endeavouring to obtain 3 hard copies of the skeleton argument as soon as possible.
I don't know if none of us has them. It sounds as if they weren't sent to our clerks.
My lords, let me now, as quickly as I can, open my application.
This is the Laden Marshall.
The Laden Marshall application, and I've heard what your lordship has provisionally mentioned. The applications encompass 6 categories of document, or 6 types of document. Type 1 and Type 2 are in fact, in reality, one category, which is 2 judgments of Lord Sanderson. The judgment dismissing the challenge to the search order, the judgment dismissing the challenge to the freezing order. using those phrases very loosely. And as I've told your lordship, there were 2 written judgments handed down on the same day, the 17th of May.
Well, for what it's worth, we read those.
Thank you. I'm very grateful for that, I should say. The second 2 types of document are, one, the 68 documents released to us in late June, the subject of the first application, and the second 8 documents released to us in mid-July, the so-called privileged documents which weren't privileged, which are the subject of the second Laden Marshall application. So those are underlying documents produced by Mr. Gollitz or sent to Mr. Gollitz or sent by his associates relating to matters in which Mr. Gollitz was intimately involved, as we shall see. The next document, which is not contentious, is a letter from the FCA. This is frankly what should be a minor point on full and frank disclosure, although Mr. Tinkler seemed to think otherwise. We don't need to trouble I don't need to trouble your lordships on that because it's not contentious that document plus some additional documents should go in. I say no more about that. The last document is a letter concerning the appointment of the provisional liquidator in Luxembourg vis-a-vis VDHI. That's not contentious. The facts I've told your lordships rightly are not contentious. So that I don't need to trouble your lordships about that either. Where the contention lies is with the 2 judgments and the underlying documents, the underlying documents came out of the search order. Now, my lords, I have spent some time explaining to your lordships the very compressed chronology under which we have been labouring, and we have been working, and I've said it again, we have been working at lightning speed to seek to assist your lordships on this and to bring in documents which we wish had come in much earlier. The reason they didn't come in so much earlier is because the 4 defendants challenged it and clogged things up. But we say, as regards the underlying documents, that they go to, broadly speaking, 3 areas. One is they lend very substantial support to the underlying causes of action in Scotland. Of course, they're not English claims, they're Scottish claims. Secondly, they demonstrate, I regret to say this, and I'm conscious that it is a big thing to say, but they demonstrate dishonesty on the part of Mr. Gollitz and indeed his associates at the time. And thirdly, more marginally, they are relevant to questions of full and frank disclosure. Now, my lords, before I show your lordship some of the documents, which I wish to do, I should just make one thing clear. My learned friends say it's all very unfair that these documents are coming in so late and they haven't had a huge amount of time to consider them, although they've managed to put in a lengthy witness statement from Mr. Gollitz on the question. They put in a 31-page skeleton on the question, which goes through each document in great detail and explains why they didn't mean what they are said to mean, or they're of no interest to anyone really, etc. But it's very important, my lords, that we understand the context in which this application is made. This is not a situation where there has been a trial and a judge has said, I find in favour of claimant or the defendant, and I'm finding that these are the facts and that Mr. X or Ms. Y has lied or whatever. We are in an inherently provisional situation here. All that is being sought, all that was being sought before Mr. Justice Lavender, before Mr. Tinkler, and before your lordships now, is a provisional order in the shape of a freezing order, which doesn't determine any rights, of course, in any shape or form. It simply creates a holding mechanism, using the phrase very broadly, pending a trial. So no one is, what I am certainly not suggesting your lordship should be doing with these new documents is saying, well, we can now make some clear findings, and these are our findings which are all adverse to VDHCJ. I'm not suggesting that for a moment. These documents are relevant to a relatively low hurdle which my client had to surmount, the Niederhausen hurdle, which your lordships know so much about, more than me, of course, which is a hurdle of good arguable case. No one's suggesting that anyone in England should be making any findings at all about anything. All we're simply saying is these documents, at the least, go to establish that which my learned friends challenge, viz. A good arguable case. And they also show, we would say, a risk of dissipation. And again, a risk of dissipation is not a final decision on anything. It is necessarily a provisional decision made at an interlocutory hearing without cross-examination, without disclosure in its fullest sense. And it's essentially a decision by a court saying, doing the best I can on the material I can at this early stage in litigation, I find or I don't find that the claimants have established a risk of dissipation such as to justify a freezing order, which is necessarily not a final decision on anything, as I don't need to tell this court. And of course, a freezing order has been in place now against my learned friends, clients, since the 17th or 20th of October. So 9 months have gone by. There's been no suggestion that the freezing order has caused any real prejudice to DHCJ or Mr. Gollitz. There's been no, and one often finds a respondent says, look, this is actually causing me quite a lot of pain, this freezing order, and can we discharge it or can we amend it so I can actually do things I'm not allowed otherwise to do? We haven't had a whisper of that. And of course, this freezing order, if your lordships were to uphold it, would only be until a trial in Scotland, which is due to take place in 2025. Which is the freezing order's already been in place for 9 months. So
there is a date for it, is there, for the trial?
there is. I don't believe there's a date for it, but I think the view of Mr. Brown, I have this not on evidence, and of course my learned friends' clients are just as much participants in that trial as I am, so they have their own. They've been attending the procedural hearings before Lord Sanderson. There's no date for it, but I think Q2 of 2025 is what it is. My learned friends don't have similar information. I'm so sorry to use such a vulgar phrase. The second quarter of 2025, I think, I'm not saying it's definitively happen in the second quarter, but we're talking about, roughly speaking, sometime in early to mid 2025. My learned friends can assist your lordships on that, because they no doubt have had communications with their Scottish lawyers about timetabling. I'm not giving any guarantees, but we're not talking about a case dribbling on to 2026 or anything like that. There's been a lot of procedural activity in Scotland. So but the critical point, or the two critical points to just preface my submissions with are, A, the documents are not being introduced or sought to be introduced to allow your lordships to make findings against Mr. Gollitz or DHCJ. So we're not talking about a final bite of the cherry. We're simply talking about whether or not they fortify the necessarily relatively low hurdle of good arguable case and the necessarily provisional decision on risk of dissipation. And secondly, that's the point that the freezing order does not appear to be causing any particular concern to my learned friends, and I don't think there's been any suggestion in the months that it's been in play that it has been. So, my lord, that's all I wanted to say. Now what I wanted to do, having explained to your lordship the rather complicated and convoluted procedural background to getting our hands on these documents, what they show, because that is rather interesting, we would respectfully say. And of course, these are only documents that derive from the Ford defendants' devices. We haven't looked at Mr. Gollitz's devices yet, so I suspect there's a very large number of further documents yet to come, which will further populate our understanding of what was going on between these various gentlemen in their private discussions in 2020, 2021, and 2022. Now, my lords, let me invite your lordships to pick up the bundle at tab 9, which is this is the bundle. This is the tab, I should say, of the first lot of documents. And I'm not going to just leaf through each document. We'd be here till Christmas if I did that. I'm going to do it thematically. Now, my lords, theme 1, which various of these documents bear upon, is the question of whether or not Mex Securities was under the control of Mr. Tahir. Now, Mr. Nasser Tahir, that is. Now, that is a very important question. Let me explain why that is a very important question in the underlying litigation. What all this derives from, all the litigation, Luxembourg, which I'll come on to, the BVI, which I'll come on to in Scotland, all has its moment of origin, one might say, from the settlement agreement reached in Dubai in December 2020 between Mr. Smith, we say on behalf of Mex Securities, and Mr. Nasser Tahir and various other senior members of Multibank. And what is known, and is not contentious, is that over a series of days in mid-September, December, there were meetings and discussions leading to the settlement. And that settlement led to Mex Securities agreeing to pay some 36 million euros to my clients, as your lordships may have seen. Now, the case that is made in the BVI by VDHI, issued in 2021, which is the case that Mr. Gollitz and VDHAG vigorously urge in this court and no doubt in Scotland, is that that settlement agreement was a dishonest sham, and that in fact Mr. Smith, this gentleman who's a defendant to these proceedings and in Scotland, but not in the BVI, because VDHI didn't join him for interesting reasons, Mr. Smith was Mr. Nasser Tahir's stooge, patsy, myrmidon, whatever phrase they use, I don't know what phrases they use, but he was Nasser Tahir's man. And this was a collusive and dishonest deal where there was no genuine negotiation between two parties, and Nasser Tahir, who's the ultimate beneficial owner of my client, simply dictated the terms to his pawn, Mr. Smith, so it is said. So it therefore follows that the question of whether Mex Securities was under my client's control, as VDHI expressly plead in the BVI proceedings, is as close to the heart of this case as it is possible to get. Now, Mr. Gollitz has ventured some evidence on this question in the English court. And I'd like to start by showing your lordships what Mr. Gollitz has said. It's in his second witness statement, which I'm just turning up now, served in November of last year. It is page 2033 of the bundle, and somebody's going to give me the tab number. 107, tab 107 of your lordship's supplemental bundle. Bundle 3, I believe it'll be. Now, I'm conscious that I'm giving your lordships a lot of facts, so I need to take this not too fast. This witness statement, my lords, of the 16th of November, served in the King's Bench Division proceedings below, is a statement served in support of VDHAG and Mr. Gollitz's application to challenge and discharge the freezing order granted by Mr. Justice Lavender.
Yep.
So this is a very important piece of evidence, because this is basically the central evidential platform for my learned friend's client's challenge to the order. It's a very important, so therefore the evidence in this document is vital to, and was vital to their challenge. Now, Mr. Gollitz has put in evidence here on a number of points. Let's pick it up at paragraph 7 first, please. Mr. Gollitz makes no bones about his position at paragraph 7. The Tahirs, that's a reference to my client's UBO Nasser Tahir and his son Yahya, who is the CEO of my client. The Tahirs have misappropriated circa 36 million euros of client money placed by VDHAG for the benefit of third-party investors in multi-bank products. Pausing there, VDHAG, one of my learned friend's clients, of course, which was the investment manager to the funds that were the subject of the notes issued by Mex Securities in December 2019 and onwards. As part of their ongoing, I quote, continue the quote, as part of their ongoing efforts to keep the fruits of their theft, they have engaged in serial abuse of the processes of the BVI Scottish and English courts. So the allegations made by this gentleman Gollitz are as serious as they can possibly be. The 10th defendant, VDHI, is presently pursuing proceedings in the BVI aimed at recovering the misappropriated funds for the benefit of these investors. So what Mr. Tinkler is being told back in December is that Mr. Gollitz has it on, he must know these facts of which he speaks, that my clients have been engaged in serial abuses of 3 separate courts, and VDHI, the White Knight, is pursuing the return of those monies. Now, he goes on, he doesn't leave it there. If we then go on to paragraph 38, he says a lot of very negative things about my clients, but I don't want to take all of them. Go to para 38, please, page 2038. Para 38, having set out a narrative, which I don't have time at the moment to go through, of what happened in the period 2017 to 2020, we're now into 2018, and we carry on, and then he talks about Mex Securities. Now, just pausing there, my lords, Mex Securities, which is at the heart of this litigation, is an entity that was on any view incorporated in 2018, and it was deployed within the joint venture in December 19 to act as the new issuer of notes which formed the joint venture, essentially. It was at the heart of the joint venture, and which brought in the investments, and it replaced certain earlier issuers. Now, what does Mr. Gollitz say here? What he sets is, if you go over the page, he sets out his belief that Mex Securities was actually controlled by Mr. Nasser Tahir. Now, that's of course absolutely vital to his challenge, because it is saying, therefore, that Nasser Tahir controlled Mex, and ergo that the supposed settlement between Nasser Tahir's company and Mex Securities was a sham and a fraud and a collusion, which is precisely how it's been put on literally dozens of occasions in the BVI proceedings. He then...
Where does he say it's controlled by?
I'm so sorry. The last sentence of 38, top of page 2039.
Oh yes, I believe.
Yeah, thank you, Michael. But he doesn't leave it there. He carries on at paragraph 39 with a paragraph which is designed to say, Mex Securities has got literally nothing to do with me, Mr. Gollitz or VDHCJ. And I would just invite you at the court just to read para 39 to see what Mr. Gollitz's evidence was before Mr. Tinkler. Yeah. So the whole tenor of Mr. Gollitz's evidence, and indeed the whole tenor of my learned friend's presentation below, was that Smith is Tahir's man, Mex Securities is simply a pawn company of Mr. Tahir. This was all a massive fraud, and what happened in Dubai in December was a sham and a collusion. Now, the Scottish recoveries cast a very different light on that evidence, and I wish to just show your lordships a few documents in that regard. We can put to one side, if you wouldn't mind, the evidence of Mr. Tahir, of Mr. Gollitz, and pick up again the Laden Marshall application, and particularly let's go to tab 9, which is where all the first set of documents are contained. Can we go first of all to what we describe as document 2, which is page 166. Of the bundle. This is an email dated November 2019 from Mr. Smith, who was the man apparently negotiating on behalf of Mex Securities in Dubai in December 2020 as its de facto or de jure manager. It's an email to Project Solutions. We know that's Mr. Ford, this gentleman who had the largest FCA fine in British legal history imposed upon him, £76 million, as to which he's paid not one penny. And it's copied to two further gentlemen, one of which is Mr. Gollitz. And it's dated November 19. Colm to Stuart. Hi, Stuart. Second paragraph, please. Concerning corporate governance in Mex Securities, SAL, this is the very entity said to be the creature of Mr. Nasser Tahir. It would be good to have an independent director on the board, brackets Mex VDH friend, close brackets. I discussed with Slava, that's Mr. Volotovsky, D12. He is happy to join. I attached a basic CV for him. There are other details such as his regulated status, and so on and so on. The next paragraph, the TMF contact. TMF is the entity that promotes companies and organises companies, has been in regular touch with me. He's away for a long weekend. The next and final paragraph, Adam and I, Adam being Adam Duffy, who was my client's general counsel, but who I think everyone accepts was playing a double game, and indeed is the subject of litigation as we speak against him by my clients. He was a close friend of Mr. Ford's and Mr. Smith's. And I will meet Alan Overy on Monday to restart the issuing process for Mex Securities. Now just, my lords, your lordships will think, well, this is a bit of hard evidence dating back a few years. Why are we being shown this? My lords, this is an email concerning the corporate governance and constitution of Mex Securities. It's not an email going to Nasser Tahir. What do you say, Gov? It's your call. You're the boss. It's an email going to Mr. Ford. What on earth is it doing going to Mr. Ford, Mr. Gollitz's close friend? And it's going to Mr. Gollitz. And it's to do with, should we get another director who's a friend of VDH, of Gollitz's company? A year before the agreement. Now, of course, Mr. Gollitz doesn't want your lordships to see this document. Of course he doesn't, because it is explosive of his case. How can it be that Mex Securities, apparently the colluder with my client, the pawn of my client, in fact, turns out, a year earlier, the discussion is being had to my client's exclusion as to who should be the director. Make sure it's a friend of VDH. Now, then we go to document 1, my lords, page 163. Now, this is a series of emails dating to October 2019, just before Mex Securities started becoming the issuer. It goes over a number of pages, and here we see, in aggregate, communications between VDH and Smith, Mr. Smith, and Mr. Ford. What on earth is he doing? Mr. Gollitz doesn't help us on that. What's Ford got to do with Mex Securities? Discussing the internal dealings of Mex Securities. So let's look, for instance, at page 163, an email from the 30th of October 2019, where a VDH man called Dina writes to Smith, copies in Gollitz, copies in Ford, top of the page 163, Dear Colm, attach please the documents for TMF. Our relationship manager is, TMF is the corporate, the company formation agents that deal with and manage from a corporate point of view, Mex Securities. Our relationship manager is a man called Peltzer. What? So this is VDH has a relationship manager with TMF, the corporate body that actually keeps Mex Securities going from a regulatory point of view, and they have a relationship manager there, VDH. But the next paragraph is even more explosive. The new team leader for us, for Mex Securities, is a man called Martin Dammit. just pause there. I know it's technical stuff, but when it's being said against my clients by Mr. Gollitz, Tahir owned and controlled Mex Securities, and that's relevant because therefore the deal with Mex Securities was a fraud and a sham. And a year earlier, VDH are talking about the team leader for us, Mex Securities. Well, sadly, Mr. Gollitz chose not to put before Mr. Tinkler those emails to say, well, although I say this, but there are a bunch of emails in my possession which came to me, which actually show the falsity of what I'm saying. No, he chose not to. He chose to suppress those from Mr. Tinkler, and my learned friends want to suppress them from your lordships. Of course they want to suppress them, because they're devastating against Mr. Gollitz's evidence. My lord, let's go to tab 4, page document 42 now, please.
Page
310. We're now straddling the period. We're now in August 2021. We've now got a text message between Smith and Ford. We know that from page 311. So this is Mr. Smith to his close friend, Mr. Ford, the man who's banned for life by the FCA from having anything to do with financial activities for his part in what apparently was a massive fraud, key data. Let's see what Smith says to Ford in August 2021, so 8 months after the supposedly collusive agreement. TMF are directors of the MS shareholder. Pausing there, everyone accepts that's Mex Securities. Mex Securities has this strange shareholder, which is a Dutch entity, which has a special Dutch name. TMF, the company incorporation agents, are the directors of the Dutch entity, the foundation. TMF are desperate to get out of their role. Remember, this is a company apparently in the hands of Mr. Tahir, who does whatever Tahir wants it to do. If VDH propose a new Dutch director, that director can appoint a new MS director, that's Securities, Mex Securities, which is a Luxembourg company. The new MS director can put MS into liquidation. No court needed. We need to discuss with MG, that's Mr. Gollitz, no one disputes that. Anyone from VDH can be the director. Me being director is at 2 extremes, and so on and so on. Please inform Mr. Gollitz, MG. So let's just pause here, because this is mind-boggling, to be frank. The evidence put before Mr. Tinkler, which is totally central to the underlying litigation, which is that Nasser Tahir defrauded the note holders by hatching a scheme with his own creature company, Mex Securities, via Smith, his man, over in Dubai. There's now a discussion going on with Mr. Smith himself as to who the new director of Mex Securities should be, and let's have it as a VDH man or person or woman. It's absolutely devastating, with respect. And I know why my learned friends are so desperate for your lordships not to see it. Because it's totally destructive of their case. And in fact, I don't want to miss out my learned friend's skeleton argument response to this. They say at paragraph 31, oh, the answer to that is nothing came of the idea. In fact, the VDH person wasn't actually, in the end, appointed. That's not the point, with respect. And I wonder if my learned friends might know that's not the point. The point is, this is a discussion about who should be a director of Mex Securities. And it's not, Mr. Tahir's not being asked. Nasser, what do you say? It's your company, you tell us what to do. No, Mr. Gollitz is being asked. Mr. Gollitz is being asked.
Sorry, this document is...
Page 310, my lord.
It's a WhatsApp message.
Yes, right.
From
Smith to, it's from Smith to Ford. We see that from page 311. That's the coding layout. I think it's Smith to Ford, right? Yeah. I don't think anyone disputes that.
So that's from the across the page, the coding layout.
Exactly right, my lord.
So this is Smith to Ford.
This is Smith, D3, the day jury manager of Mex Securities, writing to his close friend Mr. Ford, and explaining what Slava said. And I should say Slava is the name everyone calls Mr. Dobolatovsky by, who was also a de jure or de facto manager of Mex Securities.
So Slava equals Volotovsky.
That's right. But I don't want to be seen to be excluding Mr. Gollitz's evidence from my survey. So let's pick up what Gollitz has to say about this. My lords, this is in the new set of files that have been, of tabs that have been presented to your lordships. It's now, let's go to tab 12.
Yeah.
And it's very important, your lordships, I know I'm burdening your lordships with a lot of material. Very important for your lordship to see what Gollitz has to say. And he deals with document 40. He doesn't deal with documents 1 or 2 at all. Well, he deals with them tangentially, I should say. No, I don't think he does actually, no. He ignores documents 1 and 2 because they're obviously very difficult for him. Document 42 at paragraph 17, this is what he says about this, my lord.
So this is the one we were looking at was document 42.
That's right, I'm so sorry, yeah, I'm using that phraseology. I do not exactly know why Mr. Smith, Mr. Volotovsky and Mr. Ford wrote documents 42 and 43 to which I was not a party. All I can say is that by August 2021, in light of the difficulties between Mex Securities and Multibank, I was approached by Smith, who told me that the director of the Dutch Stichting, that was the ultimate shareholder, which held Mex Securities shares, wanted to resign his position. Smith suggested that I find a replacement. Now, you might think that's quite an odd thing to do, given that VDH is actually in litigation with, albeit via VDHI, with my clients in the BVI by August 2021. Why would Smith, apparently Mr. Nasser Tahir's pawn, stooge, whatever phrase you want to use, why would he go to the other side to say, who do you want to be a new director of Mex Securities? And then I think I had one call with the director of the Stichting, but nothing further came of it. And then, my lords, let me not leave this document without showing your lordships paragraph 18.
Yeah.
I should clarify that when I said in my second witness statement at paragraph 38, and they're the words I quoted to your lordships, and then this, I was referring to the period during which Mex Securities appeared to be acting in Nasser Tahir's interests. By 2021, this was not the case. So let's just pause there to analyse and consider Mr. Gollitz's explanation. So apparently Nasser Tahir's ability to control Mex Securities sort of swings like a yo-yo. One day he's in control, the next day he's not in control. One day he's up, next day he's down. I mean, it's just laughable, with the greatest respect. So how does, if Mr. Tahir controls a company, how does he lose control of that company? No explanations.
By August 2021, VDHI in the BVI proceedings were accusing Mr. Smith of having acted collusively.
My lord has it in one. Let me just pause there for a second, because it's a very important point. What, just to put, I know I'm digressing into the meat of the action, but it's maybe a good moment. It's a very complicated narrative. Everyone accepts that. What happens is that the settlement agreement occurs in December 2020. Mr. Smith leaves Dubai. There are then further things to wrap up with the settlement, which include an assignment of causes of action against VDHAG for a claim which on any view was going to be extremely substantial, given Mr. Gollitz, I don't think anyone realistically disputes Mr. Gollitz had breached his contractual obligations, or his company's contractual obligations in a pretty serious way by seeking to collapse the joint venture. There's a huge claim pending against VDHAG, which is to be assigned to Mex Securities as the issuer. Smith then suddenly goes dark, to use the modern nomenclature. He disappears. He doesn't take anyone's calls. He essentially stops participating. And this is a source of some concern and surprise to my clients. Why is Mr. Smith having been there physically negotiating and agreeing in Dubai, having left Dubai, why has he suddenly gone dark? And then we get some odd letters from Conyers saying, can you hand over, where's Mex Securities' money? Which we think, well, this is very odd. Mex Securities actually already entered into a contract about this a week earlier. So the oddities start with Conyers' correspondence in December. The oddities continue into 2021 because your lordships may or may not have noticed that there were some proceedings issued in Luxembourg in the beginning of March 2021. Proceedings which must rank as the most bizarre pleading I in my own professional experience has ever seen, which involved bizarre statements to the effect that Mr. Smith was subject to psychological and economic violence in Dubai and was imprisoned in this 7-star, I believe there are such things, 7-star hotels in Dubai. 5 is not good enough nowadays. 7-star hotel in Dubai, which he describes in the pleading as a golden prison. I mean, a totally bizarre and absurd document, but it's designed apparently on its face to impugn the settlement agreement. But on that case analysis, Smith is the coercee of Tahir. The proverbial revolver is placed to his temple. I think the phrase may even be used in the pleading. That goes nowhere because my clients get a anti-suit injunction in the BVI against Mex Securities, which is bizarre, and of course it impeaches the settlement agreement. And then, what then happens, as my lord exactly rightly has it, is that 2 weeks later, literally 2 weeks after the anti-suit has been issued in the BVI, VDHI pop up in the BVI and bring proceedings against my clients, first of all by way of a freezing order, which, as my lord rightly says, have at their very heart and centre the proposition that Smith is not the coercee of Nasser Tahir. He's not a man with the golden handcuffs and the revolver to the temple. He's in fact the colluder with VDH, with Mr. Tahir. So my lord is entirely right to raise that because one then says 4 months later, the injunction in the BVI is obtained against my clients in late April. 4 months later, the colluder on VDH's case is having private chat with MG. This is not a direct communication, no doubt there were many, saying, why don't we ask Mr. Gollitz who he wants to appoint to Mex Securities? The colluder. You literally couldn't make it up, my lords. Now, it doesn't end there, though, I'm afraid. Let's just finish off on this topic of the control of Mex Securities, documents 12 and 13. And when I say that, I mean the documents that are at page 203. I'm so sorry, 202 and following. We pick it up at 202. We're now only 2 weeks before the Dubai discussions. We're on the 18th of November 2020. This is Ford writing to Adam Duthie, who is ostensibly our general counsel, but everyone accepts is playing a double game. Adam, please give me a call to discuss this email from Colm before he starts flying kites with NASA on options for Mex Securities. My preference is that Colm doesn't meet NASA. Now, precisely the subject matter of these kites is immaterial to my submission. What this shows is that Ford, what on earth he's doing and got to do with it, who knows, is writing to Duthie, telling Duthie, keep Colm away from NASA. We don't want him to mess anything up. Fly kites, whatever the phrase used, but we can roughly work out. So let's just pause there. So on Mr. Gollitz's case, Smith is simply NASA's pawn and stooge, and Mex Securities is his creature company. So NASA can dictate what Smith does or doesn't do. But apparently Mr. Ford is telling the double dealer, Mr. Duthie, keep Colm away from NASA. Mr. Gollitz offers no explanation of that. Of that, it's just ignored, I think. And then we go to paragraph, and then we go finally to page 209, tab 13. We're in the same day, Duffy to Ford. This is the responsive email. Not, what are you talking about, Stuart? Mr. Smith does whatever Mr. Nassiter here wants. He's his man. Why would I possibly keep him away from his own man? No, understood. I will chaperone, and in the unlikely event that Colm does meet NASA, I'll keep it very short. Some creature, some collusion. Your Lordships will readily see why this is devastating to the VDHI claim in the BVI, which in any event has now pretty much ground to a halt after VDHI went bust, and to the claim in Scotland. My Lords, I want to move on to another subject which is equally important to this underlying claim. The heading is ownership of CSM. Now, my Lords, I need to take a couple of steps back on CSM. CSM is a defendant in Scotland, a defendant in the ancillary claims in England. It is not a defendant in BVI. The CSM is a company that was incorporated in July 2020, everyone accepts that, as an entity which would serve as an issuer of the kind of notes, not necessarily exactly the same type, that are an issue in this case. And a huge question mark is who owns or controls CSM. And that's relevant because CSM is said to be the subject of inducements and bribes, which I'll come back to at greater length. And it is also part of the case in Scotland that one of the reasons why Mr. Gollitz wished to bring to an end the joint venture with MGWL, my client, was because he wished to fund CSM as a new issuer of notes to continue the business, but with a company that we say Mr. Gollitz had a direct ownership, veiled, accepted interest in. So CSM is said to be in the Scottish proceedings and pleaded at length to be one of the conspirators. Now, this again has led to Mr. Gollitz putting in clear, unequivocal evidence in England before Mr. Tinkler with a view to discharging this freezing order. Let me invite your Lordships to go back to the supplemental bundle, back to tab 107, now to page 2037. We're back in the Gollitz witness statement 2, the one that was placed before Mr. Tinkler. Your Lordships were looking at paragraphs 38 and 39. I wish to now go to paragraph 28 and 27, page 2037. Now here, Mr. Gollitz has he's going through all the various participants in the litigation. He's now dealing with CSM and Colm Smith. We've seen Smith in his capacity as the de jure or de facto manager of Mex Securities, negotiating in Dubai, coming to the agreement that was engrossed in the Tomlin order in the BVI. He is now being considered in the context of his other role, which started early, as the ostensible founder and owner of CSM. And Mr. Gollitz no doubt thought very carefully about this evidence. He sets out at para 27 some words about Smith. He then sets out at para 28 this evidence. Neither I nor AG have any stake in CSM. We have no economic interest in it, nor do we have any control over it? CSM does not stand for Colm Stewart Michael, as Yahya Tahir claims. Mr. Smith told me that the name is an in-joke. It stands for Colm Smith Mighty Assets. Now, just pausing there, the evidence of Mr. Yahya Tahir at the ex parte injunction application via an affidavit he put in, which is in your lordship's bundle, Mr. Yahya Tahir put in a lot of evidence about a lot of things. One of the things he deposed to was that he had been told by Mr. Duthie that CSM stood for Colm Smith, C, Stuart Ford, this Scottish gentleman with the FCA fine, Stuart Ford S, M, Michael Gollitz. The three of them came together to bring this company into being, to be the new issuer, to take over from my clients, incorporated, as I say, in July 2020, 6 months before the balloon went up. And Mr. Gollitz is being very clear that that is wrong. The documents say something rather different, my lords. Back to, please, tab 9 of the bundle, the Laden Marshall bundle. Can we turn, please, first to document 4, which is page 173 of the Laden Marshall. Now, we have here an email. Page 173, my lords. We have here an email from Mr. Smith from May 2020, so it's 7 months before the meeting in Dubai, but just as CSM is about to be incorporated. I think it's uncontentious it was incorporated in June or July of that year, 2020. It's sent to Gollitz and Mr. Ford, Project Solutions. That's his email address. Subject, confidential, new issuer, CSM Securities, SARL, Luxembourg company. Hi guys, please see a presentation and deed of incorporation for the new issuer, CSM Securities, SARL. Right. We then go to page 175, please. We have a landscape document headed, or page headed structural overview. Fiduciary estate of CSM, a Luxembourg securitization company, will issue new notes to the investors for each asset pool, and so on and so on. Fiduciary estates, so on and so on. And then after the Roman 1 to 7 or 8, each fiduciary estate shall engage von der Heit as the investment manager. That's a reference to AG. Von der Heit, of course, is the investment manager to Mex Securities in respect to the multi-bank index. Each fiduciary estate shall pay fees to VDH. VDH can distribute management fee portions to founders, Colm, Stewart, and Michael, based upon terms to be agreed. The investors are the economic beneficiaries of CSM Securities SARL through their rights as note holders. And the way this works, my lords, as you probably know, is that investors put in their money, the monies are received by the issuer, and in return they get contractual rights through the terms of the notes that are issued. And hopefully the value of the asset pool goes up and they then receive distributions via their rights as note holders. For the purposes of bank due diligence, Colm Smith shall appear as and declare himself as the beneficial owner of CSM Securities SARL. Not because it's true he is going to be the only beneficial owner of CSM, but for the purposes of bank due diligence. What about for other purposes? We're not told. Now, my lord, that is a remarkable document, we respectfully say, because one just reminds oneself that in Mr. Gollitz's witness statement, he had categorically assured the court that he had no stake, economic interest or control in CSM, nothing to do with him. the only connection apparently on his witness statement, paragraph 29 now, between VDHAG and CSM is, to quote Mr. Gollitz, it had invested a small portion of its client's money into CSM's bonds and also manages some of the funds invested in third parties into CSM. That was its sole connection. So why is Smith telling Gollitz and Ford in May, or telling them, confirming, we're the founders? Again, let's not, I don't want to be unfair. Let's see what Mr. Gollitz has to say about this in his witness statement served on Friday. Tab 12. Paragraph 8, page 520, please.
I think just to complete this, you've missed out an intermediate stage, haven't you, where he says that Cole Smith Mighty Assets was a mistake and it was actually Cole Smith Multi Assets.
My lord's reading is if I may say so, commendable. In the interest of time, I had left it out, but I should say, my lord, I'm going to come back to it because there is another document that bears on precisely that point.
There's another one I seem to remember seeing somewhere. It said Cole Smith, something else beginning with M, which wasn't multi-assets or mighty assets.
Well, there are at least 4 different versions of the CSM initialism. Mr. Yahya Tahir said it stands for Colm Stewart Michael, and that's what Duffy told me at a meeting in 2022 where we got various people saying the same thing. They were there present. Gollitz pushes back in his witness statement saying, look, absolute nonsense. It stands for Colm Smith Mighty Assets. He then puts in within the proceedings below a further witness statement, his 4th witness statement, which my lord was, I think, alluding to, where he says, sorry, I got this wrong, my lawyers misheard me. I didn't mean mighty assets, I meant multi-assets. We've got another version somewhere in these documents of managed assets, but we then have the circle is filled.
It's actually the very next document in
tab 13, isn't it?
181. It's an email of the 13th of May 2020 from Mr. Smith to Carsten Becker at the European Depository Bank. Item 7, CSM has no significance. It's my initials with the letter M managed at the end. My lords, your reading, if I may say so, is with great respect commendable. That's document 5. I was going to come on to it, but your lordship's ahead of me. Okay. Well, we're going to see what Mr. Gollitz says about it.
Yes,
now.
that's because I don't want to be unfair.
What does he say?
Tab 12, para 8, page 520. I do not know why Mr. Smith refers to Mr. Ford and me as founders in his draft presentation. At one stage prior to CSM's incorporation, there was some discussion of Smith and me having an equity interest in CSM. It may be that reference reflects that history. However, we abandoned that idea shortly thereafter. I stand by my evidence that neither I nor VDHAG have any stake or economic interest in CSM or any control over it. VDHAG earned and earns assets on client investments in bonds issued by CSM and in relation to the management and so on. Well, my lord, one might cast a somewhat jaundiced eye over paragraph 8. And also one might ask why Mr. Gollitz, in the interests of full, if this is true, which we dispute, but of course your lordships don't have to come to a final conclusion on it, we're not inviting you to do so, why Mr. Gollitz didn't feel, in the interests of full candour, he didn't say, look, I accept that there was an idea early on that we would be all in it together, the 3 of us, Michael, Colm and myself, and Stuart, Colm and myself, but that faded away. Doesn't say anything of the sort in his witness statement. And one might also think that if it was true that the idea of him being a founder floated away, he could not provide emails to say, look, I don't really want to be involved, guys, to use their phrase. You know, count me out, deal me out, or whatever. He doesn't help us on. He doesn't help us on that. But my lords, in any event, there are further witness statements, further documents which rather confound that theory, and rather confirm that CSM and Mr. Gollitz remain and have always been rather closer than he would like to make out.
Sorry, I think I'm being a bit slow. What do you say you get out of point 7 on page 181?
Oh, I don't particularly get a huge amount out of it. It was my lord that raised it. The Chancellor raised
She
it.
asked a question, didn't she? On the previous page, on the next page, page 182, it's the previous email. What does CSM stand for?
And then there's a further. I tell you what I get out of it. Into what we get out of it. Here is Smith writing to Ford, copying in an email he sent to a particular bank, where he has set out a explanation of the initials, which is a yet further explanation to that which has been given by Mr. Gollitz in his witness statement. But there's a further document which I'm in fact, let me see if I can take.
181, so far as it goes, is inconsistent with the initials being the first names of the 3 individuals.
Yeah, except as I'm going to show your lordship, there is a further email from Mr. Well, in fact, why don't we just go there straight away? Let's go to the second batch of documents that were the part of our application. Document 1 at page 431. These are documents over which privilege was asserted but denied by Lord Sanderson. This is an email from Smith to Ford in November now, so we're 4 months or 5 months down the line. Some reference to the Treaty of Versailles, which I think we can pass over. Perhaps a little abstruse for us now. And then Roman 1, my lord, halfway down the page, pointers are as follows. Visuals, when first discussed, CSM represented equally the initials of 3 people. Michael has to be included in what we do. That was, of course, always our case, which Gollitz and his learned counsel below pooh-poohed, said it was a nonsense. Search orders rather called the lie on that. But my learned friends don't want you to see that, of course. Michael has to be included in what we do. This is November 2020. It's not some minor idea in May 2020. Oh, let's get Michael involved. Good old Michael. Let's get him involved. Oh, he doesn't want to be involved. No, all right. Michael, don't worry. You can deal yourself out. 6 months later, November 2020, 2 weeks before the meetings in Dubai, Michael has to be involved in what we do. Your lordships will readily understand why this is so destructive, we say, of the positions being adopted by VDH in many jurisdictions, including this one. My lord, I then turn back to canter further on to document 32 at page 289 within the first batch. This is we're now 2 months later in February 2021, page 289, do apologise, 289 of the Laden Marshall document. This is Cold Smith to Mr. Gollitz himself, February 21, so 2 months after the settlement agreement. And it replies to Mr. Gollitz to Smith on the February the 15th. Hi Colm, this is unacceptable. What is Slava doing? This has most probably severe implications on our CSM business. Now, it doesn't particularly matter, and it's a bit obscure precisely what has severe implications, and I don't have time to go into it. But the critical point is he's referring not to CSM as a third-party arm's length company in whom VDHAD happens to put a bit of its money by way of investment. We put it to CSM, we put it to Barclays, we put it to JP Morgan, all sorts of people we put our money into. Our CSM business. And let me be very candid, my lords. Mr. Gollitz comes back on this in his witness statement, paragraph 15, and would have us believe that a reference to our CSM business is not the business that Colm, Michael, and Stuart are all partners in some shape or form, no doubt under the counter, but it's a reference to the business VDH is doing with CSM. Well, my lords, of course, you don't need to come to any final conclusion on that question. It's a matter for trial before Lord Sanderson in due course next year. But one might note it's a pretty thin explanation. Of course, you don't need to come to any final conclusions on it. And just to place that document in the context of the preceding document, document 31, which is another email from Mr. Gollitz to Mr. Ford the day before. So on the 16th, on the 5th, no, forgive me, same day. We talked about our CSM business to Mr. Smith on the 15th. We go back to document 31 at page 287. He's same day. He's now writing to Mr. Ford. Please send all correspondence regarding our cooperation in the future setup of our independent asset management company to this address. Paragraph 3, business plan for our new business. Now, apparently that's not a reference to the CSM business, according to Mr. Gollitz. It's a reference to some yet further business he was planning to set up with Mr. Ford in February 2021. Information he didn't see fit to explain to Mr. Tinkler at first instance. It required us to go and get a search order and winkle it out in the face of opposition from the Ford defendants, root and branch opposition. But finally we got it. If you try hard enough, my lords, if you work hard enough, finally documents come out, finally the truth emerges. Now, just thinking further about this proposition that Mr. Smith, that Mr. Gollitz had no connection with CSM other than DHCJ happened to put some money into it. Let's also look at another document which has come out, which is page 448 of the. I've got a false reference here. It's the introducer agreement. Sorry? Oh, so sorry. Sorry, I've got a correct reference. So if you go to 448, my lord, this is the second batch of documents. Just while we're in February 2021, remembering that Mr. Gollitz's emphatic evidence before Mr. Tinkler at first instance, we now have a document 449, an introducer agreement between Regal Consultancy and Mr. Gollitz. Personally, this is Gollitz personally, and your lordships will remember or may remember that Regal Consultancy is one of the defendants to this case, and it is a company we say is controlled by Mr. Ford via his friend Mr. Cormack. Of course, Mr. Ford's got to be careful, given the ban, how he portrays himself. If we go over the page, the agreement is dated 26th of February. The parties are set out at page 450. Background, Regal is engaged in the business of distributing bonds and other financial products issued by CSM to fund investments in various assets. So Regal is essentially a CSM distributor. Recital B, Mr. Gollitz has agreed to support Regal's business by introducing investments into the bonds. So he's going to go out and try and get people to try and introduce investors into the CSM bonds. In consideration of MG introducing investment into the bonds, Regal has agreed to pay introducer fees and other remuneration to MG personally. If we go to paragraph 1.1, we see the sheer scale of the money that Mr. Gollitz stood to make personally out of this. 6% of any investment. So let's just put this is pretty remarkable, we would say. Let's just remind ourselves of the situation. CSM is a company which is an issuer. It's intended to replace, we say, Mex Securities as the issuer which Smith, Ford and Gollitz utilise. Regal is a Ford company and therefore closely associated with CSM, because we say CSM is also a Ford company in conjunction with Gollitz and Smith. And Mr. Gollitz goes out to DHCJ investors in Germany mainly, high net worth investors in Germany, and says, look, I've got a great deal for you. In the CSM, they're doing a great bond issue, very much would recommend that you invest in this, and DHCJ is the investment manager, so you're in very safe hands, Mr. or Mrs. or Ms. investor in Germany. I wonder whether he told them, and by the way, every €100 you put in there, I'm going to get €6 out of that by the back door, to me personally. I doubt he did. My lord, we say that's a rather remarkable document, which again shows quite how closely connected Mr. Gollitz. We don't know precisely the connection because it's been hidden, but we're unpeeling the layers of the onion. We're getting closer and closer, my lord. I think we can safely say that. Then I've got to be quick about this, but let's go to, we now go on the same theme of the CSM connection. We go to documents 8 to 10 within tab 9, pages 194 of the underlying bundle onwards.
One nine
194.
four.
Where we have a series of documents from 194 through to 199 of communications between Smith and Ford, and indeed Mr. Gollitz as well, which, putting it broadly, I don't think I have a huge amount of time to go through them individually, show quite how concerned the three gentlemen are to ensure that communications relating to CSM don't go anywhere near the Mex system. Page 194. I sent the below email to Adam, that's Duffy. He emailed me on my Mex email and mentioned CSM. I asked him to keep CSM communication out of the Mex system. And then down the page. Hi Adam, thanks for your email to my Mex address. Stuart doesn't want us to exchange any details of CSM over the Mex email. What's Stuart Ford got to do with it? Apparently, on Mr. Gollitz's case, this is all a Smith enterprise. Ford's just somebody who happens to occasionally give advice. But in fact, it's Ford calling the shots. Keep it away from Mex. And then Gollitz writes an email, page 195, to Colm on his Mex account. Colm replies back, look, Michael, keep it away from the Mex email. Some topics do not involve Mex. Now, the explanation tendered by my learned friends is, oh, it's because there's nothing to do with Mex, and therefore, it's important to maintain, it's not because Mr. Mex don't want to be seen this, it's just, maintain propriety and order. That's all it is, said my learned friends. Well, let's look at page 198. Gollitz writes to Colm Smith in September 2020 about various matters relating to whatever it is, CSM matters or whatever, and then Smith gets sent that. Hey buddy, says Smith to Ford, be careful, Michael wrote his email to me on my Mex account. I already answered from CSM and pointed this out. I've deleted both your and Michael's emails from my Mex account. That is not, my lords, and patently not, oh, let's just maintain proper procedural matters. Let's ensure that CSM business is done on CSM accounts. This is, Mex cannot be seen to see this. Got to be careful. We don't want NASA's prying eyes over it, we say, with respect. That's the, and then just very briefly turn to page 201, document 11. Smith to Ford, hi Stuart, the amendments to both the CSM, the Mex and CSM agreements for VDH are underway. My lords, VDH was to be the investment manager of CSM. It's easy for Adam or me to issue the revised agreements. pausing there, what on earth is Adam Duffy doing drafting agreements between CSM and VDH, other than because he is breaching his duties as general counsel to my clients? I don't think that CSM needs that, but I'm happy to let Michael decide, and I will follow. Important points for Michael to consider. What's Michael got to do with it? Unless, of course, he is deeply involved in CSM, which he is. That's document 11. And then, my lord, perhaps the most remarkable document of the entire run I now come to, which is document 62.
Is this still theme 2?
This is still theme 2 about the connection between Gollitz and Mr. Gollitz, I should say, and CSM. But this document and the series of documents will tell you an awful lot about an awful lot, I would respectfully suggest.
And this is page
356 of the bundle, document 62. But we have to start, it starts at 356, but we have to start it at 358. Now, an interesting aspect of this is an email which dates back to September 2023. So it's a recent email. And what it is, my lord, as follows, is this. There is a gentleman who was then working for VDHAG called Mr. Schmidbauer, who was a junior employee of Mr. Gollitz. And Mr. Schmidbauer, no doubt a very diligent gentleman, had written an email or communication to Mr. Gollitz saying, I'm really worried about why we as VDHAG are recommending investments into CSM. Because remember, VDHAG is the investment manager of CSM. And what Mr. Schmidbauer writes privately to Michael Gollitz is in the italicized words starting at 358 all the way through to 362. I haven't got time to take your lordships through it in its entirety, but the gravamen of it is, this company stinks. It is connected to Mr. Stuart Ford, who has been given a lifetime ban and a record fine. And he then expatiates about Mr. Ford's dubious antecedents at the bottom of page 358 and over to 359. He then goes into all sorts of details about this entity. He's obviously deeply concerned about the notion that VDHAG should be recommending investments into a particular bond programme which he was working on, the CSM Note FE13 European Solar Programme, as it happens to be midway down 358. So this is it's just to understand the enormity of this document, it's just important to pause there. So this is a private communication from a junior employee to Mr. Gollitz saying, look, I think CSM's really not something a company we should be having dealings with. What does Mr. Gollitz do? He doesn't write back to Mr. Schmidbauer saying, very interesting points, Christian, let's discuss. He literally writes to Mr. Ford. Good morning, Stuart. Below rough translation of the email from Christoph Schmidbauer, let us speak later. Why on earth is Gollitz sending a private communication from his employee to Ford? This is September. Right, next thing that happens is we get there's an email on page 356 where Cormack, it's obviously been forwarded by Stuart Ford to Cormack, his right-hand man. And Cormack is devising some answers to send back to this prying, over-inquisitive junior employee, page 356. And he also copies it into Mr. Duffy, who of course is no longer anything to do with my client by this stage. He's very firmly in the camp of the Ford, Gollitz, Smith camp. So everyone's involved in this communication, this private communication between two German investment professionals. Right, what happens then? So We then go to document 63, which is a couple of days later, where we now have Smith, page 364. This is 5 days later. This is Smith writing to Ford with some points to support Michael. That's a third of the way down the page, to support Michael. This is clearly Michael's feeling the heat. People have tumbled to what's going on, or they might be tumbling to what's going on within his organisation. We need to support Michael. And then a bunch of details designed to justify VDHAG's decision to invest in CSM. And Cole doesn't leave it at that, he then forwards it on to Duffy. But just pausing there, and this is I accept moving into a different category, but we might as well look at it now. Having set out all the great benefits that CSM has provided to VDH, we then go to page 365, Roman 4, multi-bank. This is the sort of great compendium of benefits that CSM has provided to VDH. CSM people have supported VDH with multi-bank over the past 4 years, my client i.e., to initially restructure the Oaklet notes into security notes in 19, then support the various corporate actions throughout 2020, which included attempts to restructure the new Mex notes. Thereafter, we have been engaged, just pause there, because thereafter we have been engaged in lawsuits against multibank for the benefit of VDH investors from 21 to date. We is CSM, that's we. We remain in position as important witnesses to support VDH in Luxembourg. Pausing there, the claims in Luxembourg were issued by Mex Securities, the Golden Prison. But of course, it's now, as we always thought, and as is our case, those claims were actually brought by VDH via the cipher of CSM, of Mex Securities and Smith, and across various global jurisdictions to recover our 44 million euros from multibank for the benefit of VDH investors, and so on and so on. Now, my lords, all of my lords, of course, have got very extensive experience in this type of litigation. But the actual arrival at a document actually revealing the conspiracy is a rare thing. But remarkably, we have it in this case. The actual conspiracy is laid bare there. And I'm going to come back to other documents which bear upon that. I'm conscious I'm moving slightly away from my theme, but I thought we've got to look at the full run of these documents in September 2023. That's document 63. We then have perhaps the most remarkable of all, document 64, page 368. Now, what is happening here, my lords, is a reply has been drafted to go from Gollitz to the over-inquisitive junior employee Schmidbauer. Now, Gollitz says this email, he doesn't know who drafted it, but it was sent to him by Ford in September 2023. This is 5 days after Schmidbauer had started asking the rather difficult questions. We don't necessarily accept it was written by Ford or Smith, but it doesn't matter, because whoever wrote it, it's devastating. So remember, Gollitz and Ford had discussed matters. Let's talk, says Gollitz, after he receives the difficult email from Schmidbauer. But within days, a response has now been cobbled together, which draws upon some of the things Smith has said, some of the things Cormack has said in the earlier emails that have been generated. First of all, he's absolutely furious with Schmidbauer. I was surprised and disappointed to receive your email. Shoot first and ask questions later is what you're doing, Christoph, halfway down the page. Why? He may well be disappointed and surprised, because Schmidbauer's putting the heat, perhaps Schmidbauer doesn't know this, but in fact, he's putting the heat on Gollitz in a big way. Then we have the litany of benefits that CSM has provided to VDH. Historic relationship, revenue stream, new fiduciary estates, and then 1.3, CSM support for VDH and claims against multibank. And of course, this draws from the email I've just shown your lordships. But this is a document sent to Gollitz with a view to him, so he says, with a view to him sending it to Schmidbauer to shut Schmidbauer up. I just ask your lordships to read 1.3. It lays bare the conspiracy. What on earth is CSM doing engaged in lawsuits in BVI and Luxembourg? Because there are no other lawsuits that could be referred to. My learned friends doesn't want you to see this document. Of course they don't want you to, because their client's conspiracy is being laid bare before this court. Over the page, my lord. Page 370 now. Stuart Ford is not an involved person as you suggest. He has nothing whatsoever to do with CSM or VDH, other than as an occasional introducer of new business or as a potential investor. Pause there, my lord. That's a flat lie. And not even Mr. Calfon's going to stand up and say that's true, because he couldn't do. The idea that Ford is just a occasional introducer, where every document, his hands are all over it. He's being asked, do you agree this? Do you agree that? This demonstrates that Ford, with his ban, his lifetime ban, with his £76 million fine, he's got to act in the shadows. But he needs enablers to do so. And my word, he has enablers in Mr. Smith and Mr. Gollitz. And then Mr. Gollitz is apparently going to tell Schmidbauer, I don't really know Ford very much. Down the page, I've occasionally met him, right at the bottom of 370. And so on and so on. I haven't got time to take your lordship through the totality. But clearly, Gollitz is very worried indeed. And an email, a letter from him to Schmidbauer isn't necessarily going to be good enough. We go to document 65, page 377. This is we're now 5 days later in September 25th. This is a communication between Smith and Ford. Hi Stuart, I'm in Frankfurt today to meet ICF, blah, blah, blah. Will it help if I also visit VDH? Ford, not sure. As Michael is sacking Christoph today or tomorrow, I'll call you to discuss. Michael is sacking Christoph. Christoph, you remember, Mr. Schmidbauer, the over-inquisitive, over-conscientious junior employee who has got close to destroying the whole racket. There's only one thing for it, it's got to be sacked. Now let's be very fair about this. What does Mr. Gollitz have to say about this litany of documents? Tab 12, page 522, please.
Yep.
Tab is paragraph 20. I just asked the court to read para 20 to themselves, please. And it will be a matter for the court to consider whether this is an adequate answer to the matters that I have laid out before your lordships. So apparently it's just a huge coincidence. The Schmidbauer is about to be sacked in September and for whatever reason, so he claims. We don't necessarily accept this, but it doesn't matter. It was postponed until the beginning of 2024. But the real question for your lordships is, why are Ford and Smith having a private communication about the internal personnel policies of DHCJ on the 25th of September, page 377? What's it got to do with them on the DHCJ Gollitz analysis of life? Why do they even know about it? They can only know about it because Gollitz has told them. Christoph gets the sack tomorrow. Unless perhaps they just happen to have a deep academic interest in German employment practices. I think not. The answer that Mr. Gollitz gives screams out for, it raises more questions than it answers. Those documents are devastating, I respectfully suggest to your lordships, not just to this appeal against my learned friends, but to the underlying cases that have been brought against my clients in Luxembourg and in the BVI. So my lord, the next document I was going to show you is document 1 in the next bundle, but I've already shown you that. That's page 431. That's the email about the who is well, and what I didn't do, and I should have done out of fairness, this is the document 431 which I showed my lord on when I was questioned, and I jumped straight to it. I didn't show your lordship what Mr. Gollitz's response to this is, and I should do out of fairness. Back in tab 12 of the bundle, Gollitz witness statement 5. He deals with this at para 21, page 522. Again, I don't think I need to read it out myself. I'll just let, if I may, the court read para 21 at page 522. This is in response to the initialism. It's the three people. It's Michael, Coleman, the three musketeers. Michael's got to be involved in whatever we do. Your lordship may think Mr. Gollitz's response is not an adequate one. So, my lords, we say, with respect, that the evidence, we're not asking, of course, for final conclusions or fact findings, because that's not your lordship's task. We sit here in a subsidiary and subordinate jurisdiction to assist the Scottish court in its endeavours. But my learned friends say, nothing to see here. It's not even an arguable case. It's all rubbish. We respectfully dissent from that, and that's why we're respectfully laying before your lordships these documents. My lords, the next heading, which again is material, of course these all documents are doing me double work, because they are A, showing your lordships that there is obviously a very good arguable case, but B, they're showing quite how the extent to which Mr. Gollitz is prepared to lie to the English court to cover his tracks, and that of course goes to risk of dissipation. So your lordships will think, well, Grant's been on his feet now for 2.5 hours. Of course I accept that, but it is doing quite a lot of work, these documents, in various aspects of my appeal. My lords, the next heading is conspiracy, the conspiracy claim itself. Of course, I've touched upon this, but let's just turn to what Mr. Gollitz says in his witness statement again about this. We pick up the main bundle, back to tab 80, back to page 2043, which is tab 88? 107, sorry, tab 107, page 2043. We're now in a section headed the consent order of the BVI proceedings. We are now talking about, or Mr. Gollitz is talking about, events of December. And your lordships may recall from the judgment and from the skeleton arguments that everything starts in this case with Mr. Gollitz either putting a call through to Mr. Tahir or sending him an email, doesn't really matter, saying, big problem, NASA. We have recently discovered that the VDH funds, which are invested in your multi-bank index, are invested illegally because of certain EU regulations about the kind of funds that UKITs can be invested in. And we need to redeem a lot of money pronto. Your lordships may recall that Mr. Nasser here was somewhat perturbed by that, given that that ran flatly counter to the terms of the joint venture agreement that had been reached, and flatly counter to the fact that Multibank had poured tens of millions of euros into the joint venture and into supporting these notes. And Mr. Gollitz's position was, well, c'est la vie, bad luck, sorry about that, old man, we have to withdraw. Mr. Nasser here took the view that was not necessarily the be-all and end-all. It wasn't as easy as that. And your lordship will recall then that Mr. Smith flies out to try and solve the problem. And so one of the questions that Gollitz turns to in his evidence is what he knew or did not know about what happened in Dubai. His case is, set out at paragraph 60 onwards. I knew that Smith was flying to Dubai in early December. I think that Mr. Ford told me that he was going to discuss alternative projects to replace the existing projects with multibank. I do not recall having any particular fear that multibank would sue VDHAG at this time. Interesting thing to say, given that he just effectively torn up the joint venture. It is wrong to say, as Yahya says in one paragraph of his first affidavit, that I was putting pressure on Ford to take action to stop multibank suing AG. And then para 61, I had no information about what Smith was talking about with NASA and the other representatives in December. While I spoke to Smith on the 14th of December and the 16th of December, I cannot remember what we spoke about. We might have spoken about potential alternative projects with multibank. And one's ears prick up when one sees that, because one then turns straight over back to page 2042, my lords, paragraph 55, where Mr. Gollitz records his evidence as being, and his recollection as being, that when multibank said, actually, do you know what? You just redeeming your funds and walking away isn't, it's not as simple as that. He then tries to redeem the totality of the VDH funds from the index and from the issuer. Multibank refuses, and he then says, I could no longer trust them with my client's money, them being my client, multibank. With my client's money, I VDHAG's money. So on Gollitz's case, by early December 2020, there is a huge issue between him and multibank, and he is deeply distrustful of my client, apparently. But then he hears that Smith's going over to discuss matters, and oh, it's all going to have, you know, happy families. We're going to have let's work out some new projects. Quite how one squares that discrepancy is one of the further mysteries of this case. And then let's finish the end of paragraph 61. You see what Mr. Gollitz says. So I knew nothing about what was going on in December. I knew nothing about Mr. Smith's communications. Well, again, the new documents provide a different story. Let me now go back into tab 9. My lords, it's 1 o'clock. Is that a convenient moment?
2 o'clock, please.
Thank you.
Right.
Court rise if able.